So today, thanks for coming to this Estate Planning 101 program on your Saturday. So we will go over basic information about estate planning today. So what's on estate planning, and do I need estate planning? And if I do, why? How does it help me and myself and my family member? Or to set up an estate planning, what do I need to do? So these are the basic information what estate planning is. Oftentimes we think estate planning is just for wealthy people or people who has little children, but it's not true because you're planning for your certain period of your lifetime first. There will be two stages. During your lifetime, when everything goes well, you're happy and nothing to worry about. But if something happens, such as automobile accident, you are injured severely as a result of that accident that you didn't expect, or you became terminally ill, or also you end up having dementia or Alzheimer's disease that you didn't really expect it. So in that turmoil period of your life, what will happen to your children? What will happen to your mom who needs help? What will happen to your houses that you just purchased? What will happen to my mortgage payment and bills and all the businesses and my money, little money in my bank account? So those things will require us to think about, sit down and think about at some point. So this is a scenario which could be, it doesn't look like very common to everyone, but it's not uncommon either. So let's say I and my husband was driving on the road and got a car accident. My husband died right there and I became an ICU. I know it's very depressing information, but that can happen to us. And I had several surgeries and my doctor said you probably will not be able to go back home. And my children, two minor children, 7 and 13, and they already have enough suffering mentally and physically, and they lost their father and they're not able to see mom. So who will take care of my children? And who will take care of my bills? What happened to my houses? Excuse me, all these questions, you probably have to have the answer based on the situation. Let's say you have nothing prepared. You didn't have anything in writing. Someone else who could be your ex, who could be your in-law, who could be your neighborhood will step in and trying to help you in the way that they want to, or government. Some public guardian's office will contact you because your neighborhood said there's a house and I heard a young couple just got a car accident. And it's been trespassing and people were making noises and somebody needs to do something about it. And government people will come and then try to take the role of yours. Also a stranger, like private professional fiduciary can step in. They are well educated, they are well aware of what they can do, what they cannot, but it's also they never met you, they really don't know where you put the most value of your life. On the contrary, let's say if you have estate planning in place. So your agent or your successor trust that you had named on your estate planning document will exercise or will implement what they are supposed to do. Everything is done as you directed in your durable power of attorney for financial purpose or as also advanced healthcare directive. So let's say you had named someone in your durable power of attorney for finance purpose, and you had named Larry to take care of your cabinet businesses. So he knows about the business inside out, and he knows how to read the bookkeeping records. So he will probably make arrangement, either close out if it's not going to work well. At least he can collect the money, account receivable, and make that flow into your family expenses. Or your best friend, Gabriella, who lived next door, will be able to go to the bank and get some, withdraw some funds, so pay your monthly mortgage bill, so at least it can avoid your foreclosure. And she can take care of your children because their kids go to the same school. And She knows what, where you put your most value in your life. We've been discussing it. Also, because of that, she can make a decision for you. If nobody's around, Gabriela will step in and she will make a decision what's the best for you and what you would have done if you are capable of making decision. So all those naming agents with detailed direction will eventually help you suffering less and your leftover family member feeling a lot less pressure. And when they make a decision, they can do with more confidence and faith. So we talked about power of attorney. So if you are alive, but if you cannot make a decision, you name the agent. It's so-called attorney, in fact, under the durable power of attorney, let's say for finance purposes. And durable power of attorney means you name someone, and then that person's authorization remain when you cannot make your own decision. That's why you hear sometimes durable power of attorneys. And for example that I gave you, I had a car accident in March, the end of March. April 15 is the big day for me to report my income tax. Nobody is stepping in to sign my tax report. Gabriela, as a named agent, could have done it. Because 1 year goes by, second year goes by, I was a good citizen, but somehow because I was not able to sign my tax document, and I was imposed with a huge penalty from IRS like a few years later. And also your agent can handle any non-trust asset with the power listed in your durable power of attorney. And Advanced Healthcare Directive is very detailed information. So when you become hospitalized and you're not able to make a decision, what you think the life what's important in your life is different from someone else, even from same siblings. Maybe I want to prolong my life to the greatest extent because I've seen some people revive after a certain period of time. But maybe your younger sister doesn't put any value on it. So if your younger sister becomes your agent, she may make a different decision because you have different value. But you can name just someone to act for you in the power of attorney, but that's just naming someone to act for you. Instead, power of attorney for healthcare, you can name the Advanced Healthcare Directive, which include detailed directions. So even if you named your sister who has different value, she will follow directions listed in Advanced Healthcare Directive. That's why sometimes you hear power of attorney for healthcare. But nowadays, a lot of people have Advanced Healthcare Directive because things happen so much, and whether you want to have artificial nutrition or hydration, or like how many days you want to be left if you become a coma. So all kinds of detailed information you can list there, or whether your religious principle needs to be honored or not. So it will help your family who is left over instead of confusion. On top of their sorrow and sadness, at least you can reduce their pressure and then give clear direction. So you have estate planning, not just all about money. You planned during your lifetime in case you're not able to make your own decision. That's done by power of attorney for finance purposes and also Advanced Healthcare Directive. Two document works pretty well for that situation. So what if you died? So we all die. Some of us will die expectedly, some of us unexpectedly. So what will happen? All my spouse and houses, business, same question we can ask. It's up to what you have and how you made an arrangement. We heard about probate, and everyone is talking about probate is so horrible, it takes long and very expensive. So non-probate transfer is you can name the beneficiary on your bank account, and upon your death, it goes to your beneficiary directly. So that asset is out of probate proceeding. Also, you have you hold the property with someone else with the right of survivorship. So for example, joint tenancy. So you own a house with someone else as joint tenancy. When you die, the another owner will take the entire 100% as to that person. And also you have an asset instead of just your individual name. You probably heard of the living trust. If asset is held in the living trust, it avoids probate. So there are some ways that you can avoid probate. And once again, I want to emphasize, if you have estate planning, such as a living trust, the disposition under the terms of document will avoid probate. So here is the popular probate. Assets worth over $150,000 as a gross fair market value. If you have, whether you have a will or not, it will go to probate. So some of us think, I have a will, so I don't need estate planning, which is not true, because the value, it's very easy to have $150,000. If you own a house in San Francisco or Bay Area, no question, it's easily over $150,000. You may owe a lot more than that, sometimes upside down, or you have second mortgages. So it's not, so your equity doesn't count. It goes by fair market value. So if you own a house in this area, it will go to probate. So what's a probate? Why is it so bad? Probate is the court proceeding transferring the property of the decedent based on intestate succession law of California or the terms of will that you have. Also, the probate court will validate whether the will is a good one or not. And in doing so, probate court will monitor if the process is going okay, it complies with all the laws and requirements. Again, probate is triggered when gross fair market value is over $150,000. Is it really that bad in probate proceeding? I used to work at probate, so some of them have good things in there. Court supervises person representative's action. If it's a huge estate and there is one professional person taking care of it, somehow you doubt it and you're not sure if person is doing a good job or not. Yes, someone is monitoring and I will like it. And there is a creditor's claim allowed. So upon the appointment of the person rep and when the official letter is issued, maybe 4 months window period. After that, creditors is just cut off, which is good if you have a lot of liabilities. But those advantages is highly outweighed by these disadvantages. You are losing a lot of money and energies because court proceeding takes such a long time. Once you start proceeding, you will get a hearing date probably 3 to 4 months later, and you are appointed if you are lucky, if your paper is perfect. Otherwise, and then you go out and then do whatever you need to do, and you have to come back to the court, get the permission that this is what I did, so let me distribute the remaining asset to so-and-so. So entire process could be 2 years or 3 years. And if there is a family dispute, and then I just don't know how long it will take. It's also privacy. It's a public record. Anyone knows you can go to the court and look at the document. They will find out all of your dirty family secrets. And if you don't care, that's fine. But your loved ones will maybe get a look from your neighborhood, and they all know about your family issues. So you are losing your privacy. And there are so much rules and technicalities you have to follow, technicalities. And also filing fees. Each petition requires $450. I think in San Francisco it's extra fee for $450. Let me show you, this is an example of so much rules and technicalities. It's just first page. You're welcome to go to court website and look at how to do probate or any other website. It's just beginning of getting the first document and petition. And fees, each petition is $450. Not that you will need the entire petitions. You may need just first and last petition, but you never know. If there is anything unclear, you may need to file petition for clarification, and your family member maybe dispute and then file the petition to petition for order for you not to do anything. So there are too much technicalities and rules that oftentimes attorneys confused as well, and it's tough to do it by yourself. And because it's hard to do by yourself, then you hire an attorney. There is a statutory fee guaranteed by probate code section 8800. So let's say you have $1 million. It sounds a lot, but if you own a house in this area, it's well combining with your other asset $1 million. $46,000 to attorney plus to the personal representative. So $92,000 will be deducted from your actually net proceeds. So for $92,000 is taken out from your net proceeds. And also, mind you, this is not including any extraordinary fee and other fees. If there is a sale, they may ask any extraordinary fee. So you will end up paying $100,000. So we talked about estate planning has a component of advanced healthcare directive and power of attorney. And upon your death, trust and wills will come in handy. What is a living trust? We heard about it. It is like a living animal or something. It's the same interchangeably used inter vivo trust and revocable trust, because basically you are making trust. You are making promise to yourself and you do make it during your lifetime. So you are creating new entity, which is called a trust. I know it sounds abstract, but think about this is a cup. You are making a cup named A. Young Kim's Living Trust, and you are putting all the assets that I have put into the cup. And will is, as I said, will go to probate, but at least if you forget to change the name of any asset to the trust, we are making pourable will, so you are pouring over that asset into your trust. So your typical estate planning document will include pourable will and living trust. And in case if you don't trust what I'm trying to say, we have included Wikipedia information. I know we all love Google and Wikipedia, and it says right here, property held in revocable trusts created during grantor's lifetime also avoid probate. So when you have an asset held in your living trust, it will avoid the probate proceeding. So how does that work? Living trust. I want to set up a living trust right now. And you will get a questionnaire, big, thick booklet. It looks like a whole book. But it's a good chance for you to think about what I own and what I have, and also at the same time, how I want to be treated if I'm not able to make a decision. And upon my death, whom you want your children to be taken care of by. Also, how you want to dispose your asset upon your passing. So you will fill out your questionnaire, and you will meet with an attorney, and it looks like a big binder which has all the legal jargon, but it's actually crafted for your own needs. So each paragraph has its own meaning, and if you have particular requests, and you will ask the attorney, I don't want to have my third sister take anything upon my death, and I don't want to have my brother take care of my children. So all information and your wishes will be included in the living trust document. So some of us are confused. Now I have a living trust, so I cannot use my asset in the way that I used to. The answer is no. It is still your asset. You still have ownership of it. You are managing it for yourself, and you are the one who's getting the benefit of it. If your child is saying, Mom, you have a living trust, you cannot spend any money on it, that is not true. So you are wearing your trust maker hat, and you are wearing trust asset manager hat, and also you are wearing your beneficiary hat. Once you are passing, someone else, which is successor trustee, will come in and manage your leftover asset. And once you are dead, the beneficiary is replaced with someone who is named in line. So trust is still your asset. Now the trustor then holds a title as trustee. That's only the difference, but it's still your asset, you have the same control. But one thing that you make sure is that once you establish the trust, make sure you put that asset into your cup of trust that you just created. Because if you forgot to put it back to your trust, all the highly praised benefit having a living trust will become vain, and you have to go to the court to allow, asking the judge to allow you to put the asset back in the trust. So make sure, what that means is you're not giving the trust money, it's just you're changing the title of your asset from you individual to the trust, to yourself as a trustee. So I used to own, let's say I used to own a condo at Young Kim, and now I created my living trust. I changed from myself name to A Young Kim as a trustee of A Young Kim's living trust. So it's still my condo. I can sell it, and I can rent it out, and whatever I want to. 401k, so retirement plan or life insurance is not going into trust, but you named someone as a beneficiary, and that person will take it upon your death. If you cannot think of anyone else, you can name trustee your trust as named beneficiary. So upon your death, life insurance proceeds will flow into your living trust that you created. But personal property, stock, and your business and your houses all can go into your living trust. So you plan for during your lifetime in case you cannot make decision for you. And after death, you make a decision where the asset needs to go. So do I need it right now? I don't know. It's up to you. You can wait another 10 years. And then if something happened, maybe you will think about today's workshop. So I think it will give you peace of mind when you came here with the intention or hope that I can set my estate planning. So I think it's a big jump. Let's say whether you have any asset or not at this time, as I explained, durable power of attorney for financial purposes and advanced healthcare directive, we all need one because you're doing it for your loved ones. And if you have an asset, it's not quite over $150,000, you may need a will. Even if it goes to probate, at least it will avoid it. The asset will go to complete stranger, your fifth cousin living in Virginia you never met. Instead, you can direct your asset goes to your goddaughter or godson who will need money to go to college, so you can contribute something into their life. If you are thinking that's more meaningful, I highly encourage to go and then make your will. At the same time, if you own a real property and if you are young and you think there is a chance that your asset will grow more than $150,000, living trust and probate will do a well job upon your death. So it's up to you. If you need it right now, and then let's think about it. If I were you, I will just think about it and take an action. And so that will give you some peace of mind, and it will take some money but upfront, but you will get a higher return when time comes. We have like 1 minute left for questions. So yes, go ahead.
I have something in front of me called durable power attorney for healthcare. Is that the same as a directive?
It looks like, yeah, it's a healthcare directive, but I don't know if you have any detailed directions in your document.
I was trying to read it.
So it looks like several pages.
Right.
Yeah, so it may have detailed directions. So it's the same thing. Yes, Advanced Healthcare Directive.
Okay.
So just like herself, you executed sometimes and then you forgot about it, and now you're not sure if I did it or not. So it's recommended you review your document like every year or every 2 years. Yes, go ahead.
Can I ask a quick question if I need to call you?
Oh, we will, Kendra and I will stay here for the questions, so you can just come up and ask us.
I just have one.
Yes. So we both are working for HERA. We are staff attorneys in HERA, and HERA is a nonprofit organization located in Oakland. And for estate planning, we charge reasonable fee. It's based on household income. So if you are interested in call this number and then leave a message. I will get back to you. And thank you for staying and not falling asleep. And so hopefully you made a productive day. Thank you very much for coming. Thank you.